Hi guys, I'm Soujanya, and in my previous video I discussed about essential elements of a valid contract. But consideration is the most important term of a valid contract. The Latin maxim quid pro quo, which means something in return, signifies that part of a contract. Now let us look at section 2D of Indian Contract Act, which defines consideration. It states that when at the desire of the promisor, the promisee or any other person has done something in the past, present or future or abstains from doing in the past, present or future, then such act or abstinence is said to be consideration. But what is abstinence? It simply means restraining oneself from doing something. Now, consideration, it simply means the benefit that each party receives when entering into a contract. Now let us look at the types of consideration. In the first example, there is a man A and he saves the life of B. Then B, to the gratitude of A, he promises to pay rupees 20,000 to A. Here the consideration is passed as A did before the promise of B. Now let us look at the second example. Here a man goes to a shop and buys a bunch of fruits, and he immediately pays to the shopkeeper the money. Here the consideration is present or executed. Now let us look at the third example. In the example, there is a man and he promises to pay the amount to B if B delivers a book to him. Here the consideration is future or executory. Now let us look at the essential elements of a consideration. First, consideration must move at the desire of the promisor. This principle has been laid in the famous case of Durga Prasad versus Baldeo. In this case, the plaintiff, he built few shops in the market on the order of the collector. The shopkeeper who occupied one of those shops promised to pay plaintiff the commission on the article sold as a consideration. The plaintiff then sued the shopkeeper for the recovery of the commission. Since the plaintiff had not constructed the shops at the desire of the promisor, who is the shopkeeper, there is no valid consideration because he constructed on the order of the collector. Now let us look at the second essential element of a consideration. It is the consideration may move from promisee or any other person. This rule has been laid in the famous case of Chinnaya versus Ramaya. In this case, an old lady by deed of gift made over certain landed property to the defendant, her daughter. Then the terms of the contract states that the defendant should pay Rs 653 as annual payment to the plaintiff. But she refused to pay because there is no consideration from the plaintiff. Then the plaintiff sued the defendant to recover that amount. In this case, the court held that as long as there is consideration, it is immaterial who has made it, because consideration can move from promisee or any other person as stated in section 2D of Indian Contract Act. The third essential element for a consideration is consideration need not be adequate. While the law allows the parties to decide what an adequate consideration is, but it should have some value and it should be real in the eyes of the law. But what considerations are lawful? Only those considerations which are not forbidden by law or does not defeat any provision of law or is not fraudulent or which the court does not regard as immoral or does not involve any injury to the other person is lawful. The last and the important essential element for a consideration is an agreement without consideration is void. This has been described under section 25 of Indian Contract Act, which states that there are few exceptions to the statement an agreement without consideration is void. When the consideration is made on account of natural love and affection between the parties, and when the consideration is made for compensating someone for his voluntary services in the past, or when the consideration is to pay wholly or a part of debt which is barred by law of limitation. Thank you.